So Joe, we have to start with that allotee a secured creditor point of view.
Hmm.
We had left that.
Yeah, yeah.
So we have to start from there and then move on to constitution and then go to claims and constitution.
Hmm, hmm, hmm.
So once you finish that allotee wala,
Hmm.
and then once we get to moratorium, uh, maybe half an hour, claims tak half an hour ho jayega, then we can take questions. Yeah, if it takes more, then we can stop in between.
हाँ हाँ हाँ
Because the important judgments, etc., we have discussed last time only.
या या
करते हैं फिर ब्रॉडकास्ट 6 तो हो गए।
क्वेश्चंस तो काफी आए हुए हैं।
हाँ, क्वेश्चंस आए हुए 6-7 तो मुझे जो आपने भेजे हैं वो भी मैंने नोट करके लिख लिए हैं।
कर दूं ब्रॉडकास्ट?
यस।
Good evening, everyone. So we will start when the participants are added. The participants are being added right now.
It is already live on what? It is live on YouTube, or it is actually दिखा live on custom live streaming service.
But it is live on YouTube also.
It is live on YouTube also.
Because today we have a lot of registrations, so a lot of people will be able to access it only on YouTube. We might have the limit on this one.
So we'll take 2 more minutes to come to that level of optimum participations.
Yeah, I think 2 minutes we should be able to.
Yeah, yes.
People plus.
In the meantime, I will actually, I will say like good evening, or probably I will say good evening to all. So I think this time also is not really very well placed time. People are on way, people are just trying to. So I think next time we will not choose this time. What do you say?
Yeah, we can look at a time which maybe, or look at Sunday 11:30 or so. That's a more preferable time.
That's more preferable time.
And
this time does clash with many other engagements that one has. Saturday evenings, although people are stuck in their houses due to COVID, but they still want to party.
Yeah.
Yeah. We still not. We haven't got out of the weekend.
Yeah, weekend is still
weekend.
All right, I think we can start now. We good evening to everyone. Good afternoon, good evening, whatever you feel like. This is part 2 of webinar on insolvency of real estate companies, the best option for home buyers as well as builders. We have with us CA Anand Sonbhadra, who is also doing multiple cases of home buyers, well experienced in conducting CIRP of home buyers. We have CA Ankit Goel, who is a valuer, and he is the founder of AAA Valuation Professionals LLP. The format would be the same. Every 30 minutes, we would have questions, and we request you all that to place your questions on the Q&A tab rather than on the chat tab of Zoom software. So the beauty is that every time we get so much excitement with the number of registrations increasing, and the exact number today that we saw before starting the webinar was 2701, and that is besides the registrations which are directly done by ibclaw.in, who are collaborating with us, and they have their separate registrations for this webinar, and those people also would be participating. So we've been using ibclaw.in for our research and for most of the orders that we are comfortably getting, although they are also improving every day. But we have seen the excitement with the promoters of ibclaw.in, and we see that it is useful for the profession. So since the part 2 is a kind of a series, so we will give you a little bit of recap of part 1. Part 1, we discussed about the present scenario of real estate industry, the reasons for this scenario, which may be partly the demand in the real estate industry, the gap of the demand and supply gap at some locations. We also discussed the present conditions of home buyers, and these home buyers are suffering for last so many years. They are not getting the possession of their flats. They have been paying. They have taken loans from their banks, and the banks are also taking installments. In case they don't pay installments, they become defaulters under CIBIL and other credit information companies. We also discussed that the insolvency is the best option for builders, because the builders otherwise will continue living their life under stress, and that stress can be huge at times, because the home buyers will go to police, they would go to EOW, RERA, consumer courts, so multiple litigation, and it's very difficult for a builder to handle it. And then finally the trust deficit, where everyone is just stopped everything. The home buyer stops making payment, the builder stops construction, the banker stops giving NOCs, banker stops giving further loans. The home buyers are not getting further loans disbursed against their home loans. The land development authorities cancel the land lease. So many difficulties at one point of time. So it is not possible to handle till the time everyone comes on a platform called Committee of Creditors. They discuss, they find a solution, and then under the IBC, there is a possibility of a resolution plan, which can be approved by the adjudicating authority. So we also discussed the options available with the home buyers under RERA. We discussed the options under the consumer protection law, arbitration law, criminal law, and also other options available under the civil courts. And ultimately we found that yes, we can get decree against builder, we can get a refund order from RERA, we can also start a criminal case against the builders, but ultimately home would only be constructed in case there is a resolution for the difficulty. The resolution for the present scenario is only to sit together and find out, and also take the use of the insolvency law provisions, which are very, very useful for handling a case where the assets are less and the liabilities are more. So with this, I can start sharing my screen. So anything you would like to add, Ankit or Sonbhadra ji, regarding the last part 1, or we shift to part 2 directly?
We should move to part 2. I think you've very crisply taken us through the happening in the part 1, and let's start with the part 2. That's better.
We have a few questions already, and we will also take questions after about 25 minutes, and then at that point in time we will cover whatever has been discussed also.
Yeah, a couple of questions I have also noted down, so we can do that.
Yeah.
So we, in fact, when we started the insolvency resolution of real estate companies under insolvency law, we started with the process briefly under IBC, because this particular webinar, we understand that a lot of home buyers are attending this, and a lot of builders may also be attending. So they have a lot of questions about the process in brief. So we discussed the process in brief. like there is an application, then the CIRP that we call commencement of insolvency. So all this was discussed in the first uh, part, and that recording of that part is available on our YouTube channel called AAA Insolvency Professionals. And for a complete link between the part 1 and part 2, we recommend that part 1 also should be seen, heard on the YouTube. So that would be really a very, very good link between the two webinars. See, we also discussed that the home buyers are financial creditors under IBC, and the status of the allottee as regard to the Pioneer Urban Land and Infrastructure Limited case of Supreme Court was also discussed in detail. How we find a resolution under the insolvency law, how we calculate cost to complete and the liquidation value. The concept of resolution was explained in the part 1. We kind of we wanted to discuss, but the time was short, and we wanted to conclude this part that the home buyers, according to our understanding, home buyers are secured financial creditors. Although this has not been held by any court so far, when we see the provisions of IBC and when we also see the provisions of FRERA, I believe that the provisions are made in such a manner that the home buyers are secured financial creditors. Even in the case of FRERA, if you would see very clearly, where my, if you can see my cursor, the RERA, it very clearly says that the under section 11, subsection 4, subclause H of the RERA, it very clearly says that the mortgage cannot be created over units in respect of which an agreement to sell has been executed by the promoters developers. And even if such mortgage is created, the same shall not affect the right and interest of the concerned allottees. So that means even the RERA says that if the agreement to sell has been entered, the property is specific, the builder's right to sell is conclusive, and then the even if the mortgage is created, the secured financial creditors, like the person, the banks who had given loan to the company, would not have any impact over the rights of the allottees, means the home buyers. So this actually has been very clear. It is also, the RERA also says that the revocation of registration of real estate projects under RERA, the association can take over, and the association would have the first right of refusal to carry out the remaining developmental work. Section 15 of the RERA also talks about the security interest of allottees in real estate projects, and is protected by preclusion operating against a developer of such project from transferring its majority rights and liabilities in that real estate project to a third party without the prior written consent of 2/3 of the allottees. So even under the RERA, the builder has no right to transfer any part of the project while the home buyers are there already. You see, in case we analyze the provisions of insolvency and bankruptcy law, we see that the secured creditor, the definition of secured creditor, and the definition of transfer of property, the definition of security interest. The definition of security interest is actually very important to understand, which talks about the performance of any obligation of any person. See, performance of any obligation. So that's one part of the security interest which probably has not been presented before the adjudicating authority or the appellate authority or the Supreme Court. See, the performance of any specific obligation is definitely there whenever we talk about the builder-buyer agreement. And the section 55(6)(b) of the Transfer of Properties Act also says that the buyer, the allottee, will have a right of specific performance. And the security interest also talks about the right of a specific performance. So saying all this, if we consider the way the definitions are made in IBC, we still feel and we understand and we would like to say that the home buyers are secured financial creditors, and they have rights which are parallel to the secured financial creditors who have taken the mortgage of the property, like banks and financial institutions. So this part we would like to say that this is the as far as the we can conclude that whenever an opportunity would arise, and in fact what we are doing is, while we are submitting any application, uh, whenever we are submitting any resolution plan to adjudicating authority, we are considering the home buyers as secured financial creditors, and we are allocating the liquidation value of the company in the same manner as normally we allocate to a secured financial creditors. So the secured financial creditors, that means allotee, and the secured financial creditors will have pari passu. Similarly, in case the home buyers are getting their homes after say 7 years, they also suffered a haircut. Similarly, the banks will also take haircut in case the assets are less and the liabilities are more. So I think we also discussed this part, the filing of an application. With the applications, we also discussed the association of CIRP, and we discussed that the application can be filed by a home buyer for insolvency of the real estate company. So the difficulty was on 28th of December 2019, the amendment came which said that in the case of home buyers, which is a class of creditor, there should be a requirement of uh, collective consent of some of the home buyers, which would be 100 or 10% of the total allottees, whichever is less. And if this number is not available for a consent application, then the application would not be considered. So this particular uh, treatment of home buyers was challenged in Supreme Court, and the Supreme Court has already given a stay in the case of Association of Carby Investors versus Union of India. So the Supreme Court, in their order dated 16th of June 2020, has issued a notice to the Union of India, and also have remarked that all the applications so far should be maintained as a status quo, and the amendment is violative of Article 14 of the Constitution. That's what is held. However, the Supreme Court is seeking the reply from Union of India. Similarly, there are other cases from Appellate Authority and CLAT, that in case any person has got an order from RERA or any consumer court, then that person would not be considered as a class of creditor. That person would be considered as a standalone financial creditor. And since at that time the limit was the threshold limit was 1 lakh only, so the individual home buyers also uh, was entitled to file an application for insolvency of a real estate company if the total amount outstanding is more than 1 lakh. So that amount has now been increased under Section 4 of the IBC from 1 lakh rupees to 1 crore. And this particular enhancement of limit of 1 lakh to 1 crore has also been challenged in one high court, but I think this would survive, and the high court finally would say that yes, this is the within the powers of the government of India. Then we come back to some of the other judgments, which says that in case of some of the builders who are actually doing their work in a ethical manner, and however their project is not completed because of some of the issues which were not in their control. So that is called force majeure, and force majeure clause was applied, and the NCL 80, like appellate authority, in fact dismissed an order commencing CIRP of Erio Grace Real Tech Private Limited. So that particular protection now the builders are taking, and otherwise also the most of the builder applications are pending, waiting for the Supreme Court decision. Similarly, so so this So far we were only discussing about the options available with the home buyers, options available with the builders, the other options other than IBC, and then we considered the insolvency applications. What are the present law regarding 10% or 100 home buyers? We also discussed that how can we file the applications under the IBC while these provisions are while the adjudication of the constitutional validity of this law is pending with the Supreme Court. In the meantime, we can also say that the operational creditors who have supplied goods or services to the real estate company can also file an application if their total outstanding amount is more than 1 crore. So they can file an application. So those applications would certainly be considered by the adjudicating authority for insolvency. In case anyone has an order from RERA or from a consumer court and he's already surrendered the right of an allottee, then his application can also be admitted separately and the company can be proceeded for insolvency resolution process. However, that amount of total order from the RERA or from any consumer court should be more than 1 crore now after the amendment. So once the application is admitted, that means the CIRP of the real estate company has started. So as corporate insolvency resolution process is started, and in that manner, once it is started, that actually means the IRP has taken over the company. IRP has all the power to take over the company, and the powers of the directors of the company get suspended. The directors are not, after the CIRP, directors are not supposed to have control over the company. IRP will control over the company. All the bank accounts would be taken over by the IRP. The office of the real estate company would be functioning under the directions of the IRP. So immediately the real estate company will come under the control and custody of the IRP. While the CIRP order is initiated, immediately the moratorium starts. The moratorium has a very, very positive impact for the resolution process as the IRP gets appointed, and during the moratorium period, no loan can be recovered from the company against the security enforcement which is owned by the company, and no license, permit, registration, quota, concession, clearance can be cancelled by any of the government authority or a regulator. No suit can be filed against the company. Maybe like no home buyer can file a suit either in RERA or in consumer court or in any other place. So that actually kind of protection available to the company for finding resolution, and the resolution time, it may take about say 9 months to 11 months. But yes, the real estate companies, I definitely feel that on an average, the time is maximum time which is allowed, like 330 days are normally achieved. Because of litigations, because of various concerns of home buyers. So during this period, assets also cannot be sold. So this is a good protection during moratorium, and in this case, the moratorium actually works for the benefit of the resolution of the company. All the claimants, all the creditors will file their claim, and like the claims, there are operational creditors will file their claim, financial creditors, and the creditors in a class, the home buyers and the debenture holders or the bond holders or the depositors, in case they are more than 10 in numbers, then they would be called as a creditors in a class. So there will be appointment of an authorized representative who would be representing this class of creditors. The workmen and employees also file their claim. Then the other creditors also file their claims. So this is important for real estate company, that the land development agencies are also supposed to file their claims, because see, in case there is any outstanding amount due to land development agencies like Noida or Noida Authority, Greater Noida Authority, or maybe Huda, or maybe HSIDC, or maybe any other land development agencies, if there are dues of those land development agencies against the project, against the company, they also would file their claims. The claims would also be filed against any of the government authority who is authorized to convert the use of land, means the authority which gives CLU and a license to construct the project. Normally, in some state it is called town and country planning. In some other states, it might be a different name. Most of these cities have their different development agencies. Maybe in Delhi we have DDA, or in any other cities we may have different. In Noida we have Noida. So in Delhi, we have some of the areas are developed by Land and Development Office, and some of the areas are developed by Commissioner of Industries. So all this is different land development agencies. If they have their dues, they would also file their claim. So in some cases where the land is not owned by the company and the company is implementing a project based on a joint development agreement with the landowners, so the landowners also would file their claim if there is some pending dues to them. So these are the claims that would be filed. So I think Anandji, we should start discussing the claims now.
I think half an hour is over. So Ankit, let's take some questions first and then move to the play. Is that okay?
Yeah.
Perfect. So, like there are questions which are respect to claim verification itself.
Yeah.
So maybe we can take those. So, in real estate companies, a big problem.
No, I think
Then
any questions regarding claim
we
verification,
can take up later.
we should take up, rather these slides will automatically answer these questions.
Sounds
So-
good. So we will put those on hold, and in the meantime, Anandji, any questions that you have identified?
there are a couple of questions that there, just looking at them.
See, Anandji, your voice is still not loud enough to be heard. And I think there were some questions which came on email, in case you can.
Looking at those only. See, the first question is coming from one Mr. CM Nath. He's talking about project in Bangalore, Dreams Infra. His question is that there are 70 odd projects in various stages. Only a few projects have got land purchased for the project. And the other projects are under development, joint development or MOU. And only some advances have been paid. Now, very few projects are ready for offering for construction of work to anybody. His question is, out of the 70 odd project, only a handful of projects can be called for bidder. So is it possible to do piecemeal resolution, that is project wise, whether NCLT will allow stage-wise resolution?
No, NCLT definitely is allowing stage-wise resolution. The only condition is that the projects which are in default, only those projects would be considered for resolution and not the entire company. So in case the CIRP of the company is started and later on somebody comes and says that there is a 10 project of this company, out of the 10, 5 have already been completed and there is no default, it's already being offered to the allottees for possession. So why should those companies and those allottees suffer for another 1 year, which is the normal time for CIRP of the real estate companies? So then the NCLAT said that yes, we actually can limit the insolvency for those projects wherever there is a default. So in this question also, if the default is there, then you will have to find a resolution. It actually doesn't matter whether the land is owned by the corporate debtor or the land is being developed under a joint development agreement by the corporate debtor. That doesn't matter. What matters is the default. In case there are allottees, and in case there is a default on the handing over the possession of the allottees, in case the allottees are interested in taking the possessions, they have paid money and they have a valid builder buyer agreement or agreement to sell, then all these projects would be considered as default, and the default would certainly be considered as under IBC. So only those projects would be taken out where there is no default. So it will be the duty of the corporate debtor to prove that out of all these projects, only few projects are under default, so that the company continues, and only the default, only the projects in default should be considered for resolution.
The second question relates to home buyer as a resolution applicant. However, I just recall we have separate slides on this particular topic where we are
This,
talking
yeah,
about.
I think we will answer while the slides come.
Yes.
There is a question on how RW can be an applicant in
Correct,
NCLT.
correct.
I think those will also be dealt
Those
with.
will also
Those
be
will get answered. Yeah.
So there were a
So
few
I think Anandji,
questions.
I think we should read the claims part of it, and there are too many items in the claim, and we can jointly take up that. Let me read the first 2-3 slides, and or you can read, you can discuss the first 2-3 points.
Slow.
Yeah,
Sure,
you
sure.
can discuss these claims part.
Yeah. Okay, what we have done here is.
I think you actually have to make sure that your voice is audible and loud enough to go to the. Yes, please.
Let me do a little bit of this thing
Engineering.
with my with my mic and then see. It may not look good, but that's okay as long as people can hear. Am I better audible now?
Much better.
Yeah. So what we have done, claims, I mean, in any CRP process, claim is a very important part of it because that determines the COC, that determines who are the creators of the company. So what we have done here for your benefit, for the participants' benefit, is listed out different situations that we have come across and the kind of challenges that one faces in real estate companies while doing the claim verification. And uh, each claim is, of course, contextual because one has to look at what are the supporting documents, what agreements, what is the language of them, what uh, uh, what is the perspective of the agreement, and what is the stage and context of the CRP process and the facts of that CRP process. So subject to these limits, we have generalized this and taken from specific issues that we came across. The first one that we have taken, suppose in a project which is under CIRP, there is a joint development agreement where the land belongs to a person X and or a company X, and it has given development right to company Y, which is the company in insolvency proceeding. And it's possibility that the right to sell may be given by the development company or the corporate debtor, which is an insolvency, to a third party. How do we go about evaluating the claims of the joint developer? In our experience, what we have come across most of the cases, it's a simple agreement which says, as a part of joint development agreement, we bring in the land on the table, and on that land, we give the developer a development rights on which it can take licenses, it can get permission from the authorities, and then once do the registrations, and then start selling the flats. And a certain part of the flats, in terms of consideration, will come to the joint developer. Such agreement, in our experience, would be a simple operational creditor arrangement where the land is being offered for development in lieu for a consideration. And then we think we have in our cases held such joint development agreement based on the facts that I've narrated as operational creditor. Now, the second situation could be, and we come across in many of the real estate companies, which is I am a small lending agency or I am a HNI, I have some money, I come and give it to uh, the corporate debtor. And what I do is, in my agreement, I make the corporate debtor agree that in case if there is a failure to repay, then as a security, you will allow me to take over flat number XYZ or unit number so. However, this particular unit does not it is not registered, the charge is not created, and it's not registered with ROC. See, in IBC, I'll just refer to some technicalities. Under Regulation 21 of liquidation process, a security interest can be proven only by three things. One is either that interest has been registered with a uh, information utility, or it is registered. You have a registration certificate or charge certificate from the ROC. It has been registered with ROC. It is there on the ROC site, or it is with the Central Registry of CIRP. If it is not there, it is difficult to prove the security. So in such cases where it's only a mention as a security measure, it is being written in the agreement that in case if it is not paid, such flat, and it's possible that some of the flats possibly has already been allotted to certain allottees. So in our experience, we have not treated any of this charge as security. We have treated all the loans by such financial creditors as unsecured in absence of uh, proof of security or their ability to prove the security. Then the third situation could be there is a financial creditor who has maybe a bank who's already got a security or a charge created on the whole assets of the project at the time of lending when the sanction letter was or the facility was arranged. It was agreed between the bank and the corporate debtor that the whole assets of the project would be created as a charge or mortgage to the lender. The corporate debtor additionally, without informing possibly the lender, goes and creates a few units, security on few units in favor of another security, another financial creditor, and also registers the charge. Now, in this situation, without taking NOC from the banks, what do we do in this situation? So there could be two interpretations depending on the specifics of the cases. Uh, One way is to look at the charge of the second creditor who has got some few units mortgaged or charge created on NOC would be taken as a second charge in absence of an NOC from the bank or the lender in whose favor the whole assets of the project was lent. So our treatment has been that the original financial creditor to whom the whole project is mortgaged retains the first charge, and any subsequent creation of charge on any units which is part of the assets of the project would be a second charge. Now, we have seen earlier cases also where in important cases we did the discussion, Ashok Tripathi and other versus Ansal Properties, etc., where what we are saying is what happens when claim by a decree and receipt holder. Uh, Going by this important case that we have listed, every decree holder or receiver letter holder uh, is a refund claimer and an independent financial creditor. He's no more an allottee. So he has to be treated as an independent financial creditor, and he can also file an application. He's not hit by the ordinance of 28th December, which is applicable to allottees. So that's been, of course, this is on very latest case, 17th. I mean, end February, March beginning, some of these cases have come. So this is a very latest one. And we have to treat such decree or receiver letter holders as independent financial creditors. Another variant is that you have a decree holder who wants possession. He has gone to RERA, example, and got a decree which says, okay, you should take the position or you should get the position, plus you should get some compensation. Now, a decree is an adjudicated debt, and it is determined by an appropriate authority with the right jurisdiction. So that cannot be ignored. What IBC law says that every home buyer can be given 8% interest in absence of any specific interest rate agreement for calculation of their voting rights. However, since a decree holder is an adjudicated debt, so whatever interest is awarded there or whatever interest rate is awarded in the decree should be taken, in our opinion. We have dealt all such decree holder in the similar manner I'm explaining. That if award has been given at the person say 10.5% or 11% rate, we have given the interest calculation at 11%, and the voting rights have been given on principal plus addition of interest at the rate of 11%. Another challenge that we face is the home loan lenders, so banks or NBFCs, SDFC or DHFL, or you have Punjab Housing Finance Limited, these kind of organizations who give loan to borrowers of flat. And when the claims are invited, hosts of them also file with 50, 20, 200 details of borrowers. What we need to look at, any claim by a bank is only tenable first if there is a tripartite agreement. Otherwise, if you look at the privity of contract initially remains only between the borrower and the bank for the loan given. So the claims made by any bank against the builder first has to have a tripartite agreement where the builder is also a signatory. And the tripartite agreement contains certain triggers, I would use the word triggers, which allows the subrogation of the rights from borrower to the bank. So one of the triggers could be possibly once the loan given to the borrower is declared as NPA and the subsequent action is taken and the bank has taken the borrower to DRT and has gotten the award. In that case, the bank steps into the shoes of borrower and he gets to, he will have the right to get the possession of the unit in place of the borrower. There could be a situation where there is a small amount of loan and the borrower also has given money. Say for a 50 lakh rupees, 20 lakhs loan has been taken and 30 lakhs has been given by the borrower, full 50 lakhs has been given. In that case, how do we adjudge the claim? Because in spite of tripartite agreement and looking at that, what will happen? Both the claims will have to be entertained against same, because if the borrower has given a large amount of money, he will not subrogate the entire money in favor of bank. So you will have to treat both of them as claimant against that unit. So bank for its loan amount and the borrower for the amount that is given separately. Now, within a project, there could be a situation where a group of companies are there and there are transfer of allottees. So from a project A, which is part of company X, and project B, which is part of company Y, there is transfer of allottees which could happen from project Y to project X. Now, if this transfer claim can be accepted, or if the records of the company which reflect such transfers, and there could be two situations, whether the money related to this booking has been transferred from the other project or not. One case could be the money has been transferred, the other case it is not. So where there have been consistent movement of money between the companies, where some booking for X is done by company B, in some booking is done by for project Y in company A, So there has been crisscross of money in that case, and if the records of the company clearly reflect the transfer of the allottee, then the claim can be accepted. But there has been no dealing except only transfer, and the money is not transferred. In that case, one has to put the claim on hold and not accept it. So two situations one needs to look at. Moving on to another scenario where possessions have been given and stamp duty has been paid for registry, but the conveyance deed or the title transfer has not taken place because the project uh, is mortgaged to a lender, and lender is not giving, a bank or a housing finance company is not giving NOC. In such case, see, the transfer, if you look at under RERA also, a transfer of title happens through two mechanisms. One, under section 17 of RERA, one, the physical possession of the unit has to be offered, and along with it, a registered conveyance title deed has to be given. Then only the transfer is complete. However, if the possession has been given, stamp duty on the conveyance deed is paid, the builder has removed that from his inventory. What is pending is the technicality of getting an NOC. In such cases, what we have done is we have not taken the claims of the, we have not accepted the claim of the home buyer, or they have not been treated as allottee because they have already got the possession, their registries happen, only conveyance deed transfer is pending, which may happen after resolution. So their claim is entertained only for the want of conveyance deed registration. Otherwise, they are not part of the COC. However, if in many projects, what happens to avoid or under pressure from buyers, the builders tend to give incorrect possession. That's the word we have used, which means to give any legal possession to any buyer, it is important that the builder obtains the occupation OC, as we call it, occupation certificate, occupancy certificate, and the completion certificate of the project, either phase-wise or for the full. Whichever it is obtained, then it is in right legal position to offer that possession of the unit. But if either of them or both of them, OC and CC, is not obtained, then the possession offered is incorrect, because OC and CC is not offered because you have not completed facilities and there are safety issues around. And sometimes buyers also forcibly take it because without conveyance deed, because they think at least we'll have the possession of the property. Conveyance deed jab karani hogi kara lenge. In such cases, whatever amount they have advanced, in spite of having the possession, their claims is accepted and entertained, and they are given, they are part of the COC forming as class of creditor. Now, there could be a tricky situation where claim of an allottee has been cancelled. Now, where it can be established from the records of the company that the claimant's unit cancellation is done with due process. As per the BBA, either the claimant has not paid or it has been due, he has not met the demand. And due information as per the terms of BBA has been given, then whatever money, if his allotment is cancelled, then his claim has to be treated as a refund holder for whatever money that the claimant has paid, and that needs to be refunded to him. However, the cancellation of the unit is not done with due process or as just a coercion measure, and it is incorrect, then if the allottee is still wanting the possession of the unit and willing to pay, one can look at accepting their claim as allotee. Now, we have also come at a situation where builders, which Mr. Goel in the first part explained, what do they do under pressure? Many a times they end up selling one single unit to multiple buyers. What does one do? So, say unit 101, and there are two, three, four buyers on it. What do we do? In our experience, we have accepted everybody's claim. So, uh, unit 101, there are three claimants. All three claims are accepted. However, the earliest allotee, so meaning the person or the buyer to whom the first sale was made, has the rights towards that unit, and the other two do not have. Uh, Accepting their claims, there are two ways to deal with them. Either give them similar unit from unsold unit of the property or the project. Only in case where the claims exceed the number of units available in a project, in those cases, it may be difficult to give them any similar unit, then they have to be recognized as a refund holder, and whatever unsecured uh, financial creditors get in return, they would also be eligible for that. Of course, for doing this allotment from unsold inventory, one has to have a mutual agreement with the party, and of course, it's a good practice to put it before COC and make the COC take a note of it or approve it. I think we have already finished with the claim by housing loan lenders. Let's move to the next one. Cash is a major component. There are many times unit allotted against cash payment recorded in the books of account. Cash receipt number is recorded in the books of account. So in such cases, many times it's done to undervalue, becomes an undervalued transaction. However, if the cash payments are recorded in the books of accounts and there are due recognition, because once it's recorded in the books of account, it finds its ways into the banking system of the company, those claims can be accepted, and the cash payments, if the receipts are also genuine, then those cash payments can be recorded. In absence of that, cash payments claim, that part of the claim may not be accepted where there is no record in the books of account, and the cash receipts given are also not the normal receipts which is given against each installment paid either through banking channel or through check or whatever.
So I think, Anandji, there are other questions also which are coming on my phone, and the questions are also coming on the phone of Rohit, who is our technical assist. So, and I think this, any claim regarding questions, Ankit, can we take up?
Yeah.
So, especially, I think with the present scenario that we would like to take up questions all regarding the claims.
So one of the questions that I think we can answer is that what are the normal timelines for the claim to be filed, and what happens in case somebody files it late? This is one question I think we can answer.
As per the regulations, the 90 days are allowed. First of all, the committee of creditors has to be constituted, and the claims has to be received within 14 days of the public announcement by the IRP. So that would be the first committee which would be constituted by submission of a list of creditors to the NCLT. So the first meeting will take place based on the list of creditors, which is a valid list of creditors as on the date of constitution of the committee of creditors. Then, as per the regulations, the claims can be received up to 90 days. However, based on the various judgments, it is actually not possible that we can say to any home buyer that since you are late, so we cannot accept your claim. And because uh, in case we don't accept a claim, that means that the person is not part of the resolution process. So then his debt would not be resolved and he would not be entitled to get any money. So that's what probably no court or no adjudicating authority would actually agree to this point, that the home buyers who failed to submit their claims within time, they would not be entitled to their home. So in various NCLT orders, it has been held that even if the home buyers have filed their claim delayed before the resolution plan is approved, it should be considered. However, in most of the resolution plans, we are also trying to provide for those home buyers who have not been able to submit their claims even till the resolution plan is approved. So even those people are also considered. Even those people are also considered in the resolution plan where the claims have not been submitted. So this is, I don't think there is any option with any of the RP or that the claims can be rejected from the home buyers. Yes. Yes,
There's
Ankit.
one I can read out meanwhile
Yeah.
Ankit is looking for. There's one from Mr. Rajesh Nigam. He says he's bought a flat in Rai Pink City and he has registry and possession both from builders, and he's also not being treated as a home buyer from the builder anymore. He's not taken any loan. However, he's come to know that the builder took a loan from Bank of India under, and his question is, since the builder has not provided any NOC from Bank of India to me, is NOC from Bank of India mandatory for me for any purposes? Is my property ownership going to be affected in both the cases if the project either in liquidation or in CRP?
So I think this is a similar case that we are already handling in one of our real
Right.
estate company, and the situation is very clear that the home buyers uh, took the possession, and the possession is also valid. It is not a possession only for fitments. The
Hmm.
home buyers also got their agreement to sell registered after paying the complete stamp duty as per law, and they are also having the possession of the property. Now, the only thing that they don't have is the title to transfer, because for title transfer, it is a condition that since their charge is registered on the entire property, so the NOC is required from the bank. So that NOC is not being given because there is a dispute with the bank or there is a default with the bank. So in such scenario, what we are doing during CIRP period, since the books of the corporate debtor also would not have that inventory, because that inventory has already been taken out when the possession was given, then the sale was booked as a revenue. When the agreement to sell was registered, that inventory has been taken out mostly, because under the Income Tax Act also the revenue treatment would be considered in case the possession is given. Under the Transfer of Properties Act also, and this will be considered as a part performance of the contract and it will not be undone. So the only thing is that the title of the property is not with the home buyer, so that title would be required whenever there is any transaction for further sale. Mostly the home buyers, they also do one additional thing, possession and the agreement to sell, and they also take a power of attorney from the builder that they would have a power to sell to any other person. So that property might be sold as a power of attorney property, but it would not be sold as a freehold property because the title has actually still with the builder. So these buyers, they would not be considered as a creditor in the insolvency of that particular real estate company. However, they would, any person who actually would come as a resolution applicant in such companies would consider title transfer to such home buyers after settling with the bank. So they would be entitled to get their title transfer. They should represent to RP that whatsoever resolution plan is approved, that resolution plan should carry a clause that the existing home buyers, they would get their title transferred from the resolution applicant. That should be there. So this is a real practical experience that we are presently having.
So one of the questions is a very interesting question from Mr. Ganesan. He says that in case of a claim received from an allotee where flat could be completed during the CIRP out of cash flow, where RP can complete construction, hand over possession, register the sale, and delete from the claim admitted. So he's asking, what if the RP is able to get the construction completed during the CIRP?
No, very right. RP has the powers to continue the construction. RP has the power to hand over the possessions. RP has the power to transfer the titles also, because these are the operations of the company.
Basically, when the CD is taken over by the RP, keeping it as a going concern is one of the objectives. And while in going concern, you can always complete some projects and sell inventory.
So as if first we can receive a claim, and while during the process, in case we could complete the construction and handover, then those claims would be taken back. Rather, those claims would be taken out of the list of creditors, and a revised list of creditors would be submitted to adjudicating authority, and a revised voting power, revised constitution of committee will happen. So those people who have already transferred the title, they have no claim, so they should not continue as a claimant in the CIRP of the company.
So I think we can move forward. There were a few questions which came in, but I think we have mostly answered them. So one question was with respect to what is the joint venture what if the joint venture partner owns land and does not file any claim?
You see, even if he doesn't file a claim, it is the duty of the RP to provide this information in information memorandum, because this information can be taken from the corporate data. That information should be captured in the IM, so that the resolution for the landowner is also found in the resolution plan. So if somebody doesn't file a claim, and however the resolution is considering that particular person, like there are many income tax authorities or many statutory authorities, they are still not filing their claims. It has been held by the adjudicating authority in many orders that since the books of accounts are available, the RP should take this information from the books of account, should be part of the information memorandum, and that should be resolved along with the resolution plan. Similarly, in this case also, if somebody is filing the claim, somebody is not filing the claim, the process has definitely undertaken. They are supposed to be the process, part of the process, but they are not voluntarily. What we should try, that we should also try to showcase to the adjudicating authority that we tried to get the information, pass on the information to the landowners, but they did not file their claim. So that would be sufficient for making them as a participant into the resolution process, and the resolution plan will be binding on them. So while the claims part was going on, I think there are a couple of things which are left here. In some cases, we have seen that the suppliers of goods and services at the fag end of the before some time, as the company would go to insolvency, the builders would the promoters would allot some of the units to the suppliers of goods and services. That means that the operational creditors are being converted into a class of creditor, which is a home buyer. So their entitlement actually has been upgraded. So this would be considered as a professional transaction, as preferential transaction under Section 43 of IBC. And see, the preferential transaction can be reported. The preferential transaction can be reported separately, because the RP has got no authority to say that this is a preferential transaction and the preferential transactions claim can be rejected. In case all the documents are available, in case the builder buyer agreement is there, then for preferential transaction, the RP needs to get an order from the adjudicating authority. Then only this transaction can be cancelled. So the RP will admit their claim. RP will make them part of the process, and in the meantime, file an application under Section 43 for declaring that transaction as a preferential transaction. So that preferential transaction can be dealt with in this manner. Some of the people who have given unsecured loans to the corporate debtor, and in that unsecured loan, the builders now understands very well that the company will go to insolvency, and that person somehow is not getting the interest and also the repayment. So the builder, under some social or some other pressures, can allot some units to that particular unsecured lender. That also can be considered as the preferential, because yes, as a class of creditor, which is a home buyer, as per the RERA, they have better they have better rights as against the unsecured lenders. Even otherwise, in case we consider the definition of security interest under IBC, the home buyers are actually a secured financial creditors because they have a security interest, and that security interest is a right of specific performance from the corporate debtor based on the agreement to sell. The unsecured lender actually is now upgraded to a class of creditors, and that to a home buyer. So that also would be considered as a preferential transaction, and that should be reported to the adjudicating authority. While the claim can be admitted, and while the process of the resolution, they should be a part of the claimant. Claims where the RP could get the registry done, that's already answered. The RP can get the registry done, so that would be removed from the list of creditors. And the claims where the RP is able to hand over the possession, but the title has not been transferred, so that claim would stay in the list of creditors. They would stay as voter, they would stay as part of the process, because see, the only possession has been transferred and the title has not been transferred. The claim would continue as the maybe that they would definitely have the claim on the company, because inventory the inventory of that particular property is still in the books of account. It has not been taken out, because simply by handing over the possession, it cannot be taken out. So Anandji, you can talk about this case where this, because it is your case, you have handled it very well before the adjudicating authority regarding this lease land. I will again take up after this slide where the lease, after this issue.
Sure. I'll just go to the sharing of screen. Now, one of the key issues which we faced with the Land Development Authority in this particular case, I would name, because we are discussing that case also, Noida Authority, and most of these landowning authorities come and file their case in the Form C, asking you to treat them as financial creditors. Now, if we look at 5.8 D, it says, in case of a lease agreement, the lease agreement can be termed as a financial lease if, under the existing Indian accounting standards, then the debt owed under that lease agreement would be a financial debt. If it is not a financial lease, then it should not be. So in this particular case, we dived into the relevant Indian accounting standard and tried to pick up what are the key things or the key substance which determines whether the dues to the landowning authority against a leased land, will it be termed as a financial debt or will it be an operational debt? Now, if you go to Indian accounting standard, in this case, the relevant accounting standard is 116, without getting into too much of technicalities, in a layman's term, what it says is, in classification of lease, a lease can be a financial lease if it transfers substantially all the risk and reward incidental to the ownership of underlying asset. Underlying asset is the leased land. If the risk and reward related to that is substantially transferred to the lessee, then it becomes a financial lease. Now let's see what are the key terms which will help us understand whether the risk and reward is being transferred. The first one that we read is, the lease transfers ownership of the underlying asset to the lessee at the end of the lease period. In our case, there was no transfer of ownership at the end of the period. The lease gave you a leasehold right where you built flats and you subleased it to So the ownership still remained with the landowning authority. The second was slightly complicated. I'll try to make it simple. The lease has an option to purchase underlying asset at a price, which means on the day of agreement, you create a certainty by which the lessee, that is the company, would be in a position and agreeable to buy at a future date at a much reduced price all the monies that they were payable towards the landowning authority and get it. There is no such condition where you have a right to buy. The third one was the lease term is for the major part of the economic life, but the land's life is indefinite and the lease is 90 years. That is also insignificant. The asset is of a very specialized nature where only the person leasing it can use it. No, that was not the fact, because here it is any builder will use land to build a project. It is not a specialized NASA kind of a mold where you are only allowed to build rockets. So it was any builder could come. And if the lessee could cancel the lease, the lessor's losses associated with the cancellation are borne by lessee. In our case, or the agreement per se here, there's no right to the lessee to cancel the agreement. And there is no right for renew the agreement. So looking at all this, let's move to the next slide. So looking at all these and the argument on all these matters that we did, in my own case, Concord Infrastructure versus Shubkamna Buildtech, and in the matter of Noida Authority versus Anand Sonbhadra, it was held that after considering various terms of the types of financial lease versus operational lease, the order of the court says, we are of undoubtable view that the present lease deed dated such and such is not a financial lease as per terms laid down under the guidelines of, and the applicant cannot be granted the status of financial creditor and cannot exercise voting rights on COC.
Thank you very much. Thanks a lot. This is a case that we actually fought and we got this adjudication. And of course, the Noida Authority has gone to appellate authority, and the hearings are also going on with the appellate authority. And we are confident that based on this concept, we have not admitted Noida Authority and Greater Noida Authority as a financial creditor in any of our COC meetings, and they have been considered always as an operational creditor. And based on this argument, we won that, and it's presently being heard at appellate authority. Uh, See, the another one important judgment which has recently come from on 10th June 2020, and that judgment is that the Noida Authority and the Greater Authority should charge only 8% interest rate on the outstanding amount, and that of course would reduce lot many claims which are there with the builders as of now, that they would only charge 8% interest. I'm not sure whether this particular judgment is under the IBC or not, because this Bikram Chatterjee case is Amarpali's case, and Amarpali's case is not being handled under insolvency. It is being handled under the Supreme Court's own powers. So we would not consider this order as 8% interest rate, because this all the insolvency works in a different manner. Insolvency works like whether the amount would be payable, that depends on the liquidation value of the company. However, this particular matter is settled when they submit a claim. When they submit a claim, then we can actually reduce their claim, and we can only admit an interest only to the extent of 8% because of this Supreme Court order in the case of Bikram Chatterjee. So I think I was getting a lot of questions which I was reading. One of the questions which came to us, like in case the land development agency does not file their claim. So I answered that it should be always considered in the information memorandum, so that the resolution is provided to all such creditors, and the resolution plan is binding on the creditors. And the other question came was whether there is a possibility of seeking waiver or reduction of the claim of the land development agencies. I certainly say yes, it is possible, because first of all, the land is a leasehold land. The leasehold land means that the claim that we are getting is basically for services which has been provided by a Noida Authority to us, and these services are lease services. Giving the land on lease is a service, and that is the reason they are operational creditors with us. It is not a loan. So when it's an operational creditor and the liquidation value of the company is lower, and it is not even sufficient for the project to be completed, then all other creditors would not be paid, including the statutory authorities, including the land development authorities, and including even the licensing authorities like the town and country planning. So similarly, there was another question whether the EDC and IDC can also be waived. So what is EDC? What is IDC? Let's understand that, because the town and country planning is a department of state government which provides some services of giving licenses and also provides some services for development, internal development and external development. So those charges are basically for providing some services based on the state government law or the local laws. So in case the company would have sufficient funds, in case the liquidation value is very, very healthy as against the creditors, then of course all this EDC and IDC would be paid. In case the liquidation value is not even sufficient to complete the project, then all other creditors would not be paid, as there is no money to pay. So this is the some of these questions that I wanted to take up, because at this stage these questions were relevant. See, now it's see the we have seen the application part, we have seen the claims part. While we receive the claims, there's so many difficulties, and accordingly we try to find the we try to verify the claims, and the see how we handle the claim verification as an IPE. We have a complete department of handling the claims of home buyers, and those people are experienced for the last 17-18 assignments that we have done for the home buyers. We understand what all has to be captured from the claims and also from the books of account. So all this claim verification, when we do, the basic information which is required and captured for the claim verification is not simply the documents and the amount due. We also capture the amount which is due from the home buyers based on the builder buyer agreement, including the preference PLCs and including the parking charges. All this is required because the information memorandum would need this information, how much money is receivable from the creditors. Then we also try to understand the how much money was paid in cash, how much money was paid in check, because in case the money paid in cash is not entered into the books of account, then we are not entitled to take those cash. Rather, there are 2-3 cases that we are handling in such manner that if the proper receipt has been issued on the company's printed receipt book, and still that cash is not found in the books of account, then we are admitting that cash payment by the home buyer, but we are trying to file immediately a fraudulent application for embezzlement of the property of the company, which is cash. In some other cases where the cash receipt has been given by the home buyer to us on a plain paper or on a letterhead of the company, that we are not admitting, and that too substantial amounts. Somebody may come that he has given the cash, and he has taken the allotment letter and then the builder buyer agreement, that those transactions are not being considered because the receipts are being issued on a letterhead. Although we sometimes feel that if that home buyer goes to any court and tries to say that this is my genuineness and I have paid genuinely cash and I have got this allotment letter and the builder buyer agreement, then some of the courts may say that yes, you might have paid cash, and the as far as the we may inform to the income tax department, but in the meantime we would also like to protect your interest from the builder. The builder has done a fraudulent job, but then your money should be saved. Although we will inform to the income tax department, that kind of scenario also can happen. So as far as the claim verification part is concerned, that when we finish that, we would actually have the information of the duplicate allotments. We would have the information of the amount due from the home buyers. We would have the information of the total unsold inventory. We would have the information of the amount, the books of accounts showing allotment, whereas no claims filed. We would also have the the information regarding different kind of schemes, like the the sub the profile funder, profile home buyers. They are also separately then there is a subvention scheme. So all this information has to be captured because it is required for a resolution. Otherwise, everyone will keep claiming that my installments were not supposed to be paid by me, it was supposed to be paid by the builder. Then we also receive claims from the lenders to the home buyer, those banks who have given home loan to the home buyers, and those also come to us when the home buyers are not paying because of the tripartite agreement between the builder and between the banker. See, the tripartite agreement in mostly, because every tripartite agreement can be different, but in most of the cases it says that in case the home buyers will default, then the builder will hand over the possession of the property to the bank and not to the home buyer, and the bank will continue, bank will pay to the home buyer the base balance amount. So those claims we actually admit partly from the home buyer and partly from the bank in case the difference is too much. Otherwise, if the amount of the default is then of course the, because of the interest of the bank, which the bank levies on the loan, the home buyer's share would be completely reduced, and in some cases it might even be nil. So then we, after the verification of the claims, the constitution of the committee of creditors, the meetings and operations of the committee. See, we, as we understand that all the financial creditors, including home buyers, will be the committee of creditors. Home buyers are financial creditors under section 58F of the code, and the operational creditors, in case they have their outstanding more than 10% of the total debt of the company, they also would be become invitees to the committee of creditors, but they would not be having any voting share. They would not be entitled to vote. The as per the law, as per section 21 subsection 6A, the uh, allottees, the home buyers are represented in the meeting of COC by way of an authorized representative who is appointed by the home buyers and or the class of creditors and is confirmed by the NCLT. So when he's sitting in the meeting, and it is his duty to appraise the home buyers or the class of creditors regarding the proceedings. But then we saw that there is a lot of discomfort which is being developed amongst the home buyers because they are not part of the process and they are sitting outside, and one person representing all 2,000 of them is sitting inside the COC meeting. So that particular scenario, we saw that there was a trust deficit. The trust deficit started developing between the home buyers and the RP. Then we introduced a new system, which is a system of appointing observers, system of appointing observers from the home buyers in the COC meeting. Now, the observers were also appointed through COC meetings where everyone voted through the uh, e-voting, and then these observers, they actually started sitting in the COC meeting. They were actually representing the home buyers. Actually they were voicing for the home buyers, and they were concerned about the expenditure. They were concerned about the transparency, and each and every decision, depending upon the voting power of the home buyers and the lenders, uh, each case the home buyers got a lot of powers, and these observers, they were actually helpful in understanding the RP and passing on the messages to the home buyers for the purpose of getting the voting done. So with this observer scenario, which is we did it officially, we submitted all our reports to NCLT. Nobody ever objected that how can you just bring out something which is not there in the regulations or in the code. So, but then yes, we brought that, and we also convinced our lenders like the banks and the financial institutions that this is a good concept, and with this concept only we actually been able to pass our most of the resolution. In fact, all resolutions whatever we have uploaded so far has been passed only because of the observers that we appointed in our committee of creditors. Those observers helped us in bridging between the home buyers and the RP. So the even the authorized representative, we understood the concept of authorized representative, and it was very clear in our mind that the authorized representative does not have any vote with him. He is only a representative of the home buyers, and he will actually provide his opinion after taking the opinion of the home buyers electronically through e-voting. So whatever resolution that he is voting, he will first get the e-voting done. So he gets the e-voting done, or directly RP does the e-voting done. So that's a simple scenario. Nobody's objecting in case the RP directly sends the e-voting link to the home buyers, or it has to go through the it has to go through the uh, authorized representative. That is not really important. We have seen in some cases that the AR gets the voting done before the COC meeting. No, we have never done that. What we are doing, and that we conduct a COC meeting along with the observers. We seek opinion from everyone. Wherever there is a consensus, we upload those resolutions, like we've been uploading the resolutions for e-voting in other cases. So in that manner, the e-voting is done like any other company. However, the e-voting in some cases may be 20 creditors. In this case, it may be 2,000 creditors, but the e-voting is done in this manner only after the COC meeting, after the minutes are circulated, after each and every query is answered in the COC meeting. You see, we also started another process, and that is the pre-COC meeting with the home buyers. We've been conducting pre-COC meetings with the home buyers. In that pre-COC meeting, we were explaining each and every agenda item, and we were answering their questions for multiple hours. And after that, we used to do the COC meeting, and after that, voting. So first pre-COC meeting over with the home buyers, we used to do physically, and now since it is a time of virtual meeting, so now we are doing on any kind of virtual video platform, which is attended by more home buyers as against the past. So now we actually do the pre-COC meeting with the home buyers, then COC meeting with the AR and the observers and the other creditors, then e-voting, and that's the result is final. So unless we connect with the home buyers, they would not understand the process. They would always feel that the RP is just here to make money. RP is just taking his fee. It will not happen. So there is a lot of apprehensions with the home buyers. So it will all be answered in case you are there to answer their questions. So otherwise, the AR individually doesn't have any power. Operational activities can be performed by the RP during CIRP. That's what we are doing in many cases. We are actually doing the construction also, which can actually continue. However, while we are actually approving any contractor or any other expenditure scenario, we are getting this. We are getting all this approved from the observers or any of their committee. The contractors have meetings with them. It's being done in a very transparent manner. The occupation certificates have also been applied by us in some cases where the other infrastructure has been created, the minimum required infrastructure has been created. Even the completion certificate can be applied by the RP. RP can allot the flats, RP can transfer the flats, RP can sell the flats. Of course, all this has to be done in a very transparent manner, and that's where the observers come very handy, because they know about the project more than the RP. So they provide the information about the market rates, they provide the information about the construction rates, because there are many of them. Normally, we actually have gone up to 22 of the observers. In one of the COC, we actually appointed 22. The reason, because there were different projects, there were different work home buyers associations, RWAs. In some project there were some people who were actually having the possession. In some projects the tower was not even started. In some projects the tower is near completion. So everyone had different interest in the CIRP. Some said that you can take another few payments from us. Our tower can be completed within 1-2 months. So then, okay, we actually got it passed from the COC, and then the tower started construction. In another case, somebody say that no, our tower is like it's not even started. So different people representing different groups in the COC by observer, in the name of observer, is a very good scenario, and this actually will help you in conducting the process in a very transparent manner. The undertaking the maintenance of the towers has also been done. Undertaking the maintenance of the overall complex where some people are staying there, that has also been done by the RP in many cases by us. Now, all this is like the operation management, and then we come to the information memorandum, because the information memorandum in a real estate company is very important document, because this will only give some information to the resolution applicant, how the resolution plan could be structured, what are the information required for structuring a resolution plan. So the one first most information, see, I already in the first part I explained that what is the resolution required. The resolution is required is that if the project can be completed, if the project has already attained a particular status that it can be completed, then first liability is the cost to complete, the expenditure on the cost to complete. That is our first liability. So in the information memorandum, we provide that by getting an estimate done from an engineer, from or the same architect who is used by the company. Then we also provide the details of the how many uh, persons submitted their claim, how many persons who did not submit their claim, however their name appears in the books of account. The total multiple allotments, refund claimers, decree holders, and the joint development partners. All this information has to be given in the information memorandum, including the amount due from allottees, including the duplicate allotments, including the subdivision of some of the properties. Then the unsold inventory is very important. Any kind of litigation which is pending, all this has to be given in the information memorandum. So at this stage, we are also trying to uh, come out with a concept that is the RWAs or the Home Buyers Association can submit a resolution plan. RWAs or Home Buyers Association, collectively or individually, they can submit their resolution plan. Now the present scenario that I am on, I have to just invite expression of interest. So when I invite expression of interest, I also provide eligibility criteria. I also provide the earnest money deposit required. I also provide the earnest money deposit along with the resolution plan. And finally, the performance security that also I provide. So now whenever I'm saying that the expression of interest I have to release in the newspaper, before that I need to understand whether there is any kind of home buyers association who would be interested in submission of the resolution plan. In case they are not interested, normally we guide them to do that. Why we guide them to do that? Because in case they are not genuinely interested in constructing the property themselves, then they can be a very big competition to the other builders who are coming from outside to take over the company. And we have succeeded in many times that the home buyers association competing with outside builders, negotiating that we are offering this, why can't you offer this? We have understood the plant, we have understood the construction cost. They said there is huge profit in case you complete this project, so we can do it ourselves, and you have more experience than us. So that negotiation helps us in finally getting a good deal from home buyers. However, while we actually release expression of interest, we actually mention the eligibility criteria. So the eligibility criteria, I will just move on to the next sheet. Now, the eligibility criteria is required to be approved by the committee of creditors. In most of the real estate cases, the home buyers are having larger power, and in most of the cases they have more than 66% of the power. And the COC will decide the eligibility criteria, because it is their prerogative that what kind of resolution applicant would be acceptable to them. And it is also the eligibility criteria that can be modified in case the no resolution plan is received, and in the second attempt of release of expression of interest, the eligibility criteria can be modified also. And the one concept that I want to inform here is that there can be a different eligibility criteria for different class of resolution applicants. I can always say that if a builder comes from outside, I need experience of at least say 1 million square feet of construction handed over to the home buyers. I can say that minimum net worth of XYZ. I can say the minimum net profit of XYZ in the last 3 years. I can say the experience in revival of the companies. I can also seek various kind of eligibility criteria and the bid evaluation metrics criteria. I can stipulate differently for an outsider builder. However, I can say in the eligibility criteria that in case the Home Buyers Association would like to submit a resolution plan, since they already have a stake in the project, since they already have invested so much money in the project, the eligibility criteria for them would be relaxed. So what would be the relaxation? The relaxation can be, number one, there would be a very, very small amount of earnest money deposit from them. Then there will be no requirement of experience. There would not be any requirement of net worth. There would not be any requirement of profits in the last 3 years. So all these can be relaxed for the association of home buyers. For builders, it is important that we should keep these conditions. Otherwise, multiple people will come only to enjoy the process, enjoy only to have an experience, but they would not be serious. So the eligibility criteria is the first stage where we need to understand, in case the home buyers submit their resolution plan, what all has to be altered. So all this earnest money deposits, all this can be changed. Second stage earnest money deposit normally we stipulate at the time of submission as resolution plan. The first stage earnest money deposit is when the expression of interest is submitted. Second stage, when the eligible or final list of RAs is released, and they are supposed to submit a resolution plan. So along with the resolution plan, they are supposed to submit a second stage earnest money deposit. And the third stage of the performance security is the person who actually is uh, who is the H1, and the resolution plan has been approved by the committee of creditors. All these three type of performance security earnest money deposit can be differential for the home buyers association. So if can be differential, then the most of the home buyers would be attracted. They would submit their resolution plan. They will take over the company and they would run the company as a cooperative society. There are thousands of examples that in this country the properties were constructed, the colonies were made based on a cooperative society where only the presidents and secretaries were working, and they were hiring the contractors, they were hiring the architects, they were hiring the project management consultant. So why can't it be done now? It can be done now also. So once this stage is concluded, then you would see that there's a lot of interest of the home buyers that they would participate into the process. So the bid evaluation matrix is also made accordingly. In the bid evaluation matrix, because that also has to be approved by the committee of creditors, the bid evaluation matrix would say that some of the conditions are not applicable to the home buyers. Some of the conditions, they have a different score, they have a different score. So all this is little complicated, but this is very, very helpful for resolution of a real estate company. So the quantitative score, the qualitative scores can be different, and it all depends upon the priorities of the parties. I've already said the qualitative score, which is otherwise applicable to a builder, and we can just put a note there that the qualitative score is not applicable to the home buyers association. And with this, we can even say that now there are home buyers association, there are builders in the race, and everyone is trying to put a proposal, and that proposal is the proposal would be evaluated. The proposal would be evaluated on a bid evaluation matrix, and bid evaluation matrix finally would declare H1, and then it will be negotiated with the builder or with the home buyers association. The quantitative metrics which is most appropriate for home real estate companies is that the upfront amount invested in the project for restart of the construction before asking any payment from the home buyers. See, when we handle the bid evaluation matrix for another company, then we say upfront money offered to the creditors. In this case, we are saying upfront money invested in the company to restart the construction before any additional amount is asked. Any amount is asked from the home buyers out of their pending payment. Next, the period in which the possession is proposed to home buyers. Then there can be negative scores for asking additional amount from the home buyers for completion of the construction. Then offering amount for maintenance for those part of the projects where the allottees are in occupation. Then the amount offered to home buyers against delayed possession. So we also have done in some case where the assets were much more, and there was a competition between the home buyers and there was a competition between the builders. Then the home buyers were able to negotiate that if you would give us the compensation for the delayed possession as mentioned in the agreement of BBA, or even higher than, then we will approve your resolution plan. So that particular builder gave them the compensation because the property prices had gone up, the unsold flats were plenty. So there was the complete calculation that how much profit that the builder is earning. So that builder, in one of the examples that I would say without naming, that the builder offered 10 crores of rupees to the RWA association for future maintenance, that the property, the entire complex will be maintained. Since there was profit, the entire complex would be maintained with this 10 crores of buffer fund, and that was offered in the resolution plan. And that kind of negotiation is possible, and that is only possible when there is a competition. We are presently handling a company where there is hardly any competition because of the COVID. Nobody was interested to take that kind of initiative. So we are now just whatever the resolution applicant says, that everyone has no option except to agree, or otherwise the company will go to liquidation. So in the real estate companies, never ever think of a situation where you only have one resolution applicant. So that's very, very scary, and it is really not. Similarly, the qualitative metrics that we normally made in bid valuation metrics, experience of the builder in terms of the quantity of the area delivered in the last 5 years, net worth or the other financial parameters, scores can be allocated for known and unknown brands of the builder. Somebody says that if the DLF will come, will actually be preferred. Similarly, collateral securities offered or some other parameters that can be suitable to the home buyers. So this is the now I have completed one part. The home buyers can participate into the resolution plan. What should be their eligibility criteria? What should be their bid evaluation metrics? What should be their earnest money deposits? And how can they structure? In case there are multiple associations, then they can 3 or 4 associations for 4 different projects under the same company. They collectively can file a resolution plan. In the resolution plan, the resolution for each project would be specifically mentioned separately. For each project, there will be a separate section in the resolution plan. In that particular section, there will be a monitoring committee that would actually, out of the home buyers only, there will be a separate account maintained for this particular project, for this project, for this project, for this project. And ultimately, the entire resolution plan would actually go to the adjudicating authority. Whereas within the resolution plan, we have mentioned that this project will be managed by this committee. This project will be managed by this committee. This project will be managed by this committee. And everyone finally collectively would contribute something for the common compliances of the company. So that all is practically possible, because otherwise there is another possibility that everyone should come out and then there is a demerger, because the home buyers are not interested in making private limited companies. They are interested that their association would function like that. So this is the entire concept of home buyers who actually can come and take away the company. They will become the owners. The shares will be transferred to the home buyers, and the board of directors will come out of. In fact, we have proposed in some cases that there will be 2 kind of committees. One would be the committee which is called the directors of the company, and that would be a steering committee, which is a higher committee. And then the second would be one would be the committee which is an operational committee. That committee will look into the operations of the construction and finally handing over and selling the project. And then one would be the steering committee. So the lower committee would be considered as a board of directors, and the steering committee and the senior committee would be considered as a shareholders committee. So these 2 committees will function while the entire project is being constructed, the unsold inventory is being sold, the contractors are being appointed, the architects are being appointed, and the entire funds are in their own control. there will be complete trust. The land development authorities, the other creditors in the market, they have no say, because whatever is written in the resolution plan is final. The land the land development agencies would also have to say yes, either they agree or they don't agree. The licenses would be renewed, and the outstanding amount from the town and country planning will be settled in the resolution plan. So this process can be considered as a much better process. So now, Ankit or Mr. Anand, in case you can see, in case there's some questions, because all these kind of questions I could see in the various questions and in the question answer tab. So in case there is still you feel that some questions are not answered which are related to this, that I can answer, or in case you can read some of the questions.
A practical question from one of our fellow professionals is that, is it mandatory for the IP who acts as AR to possess AFA from IPA?
No, AFA in any case is required before you take up any case of either RP or IRP.
So it is required for
AFA,
being an AR also?
Yeah.
No, it is required for being an AR also, because the AR has to be an insolvency professional. It is very clearly mentioned that for AR also it has to be an insolvency professional, and that too is eligible to practice. It is required. AFA assignment also it is required.
One of the questions that has come in that what happens if the builder company goes into liquidation? Now, I think this is an extension of, or maybe beyond whatever we have discussed so far. So maybe a little light on what happens if the company.
Yes, I think this is an important question, because see, everyone says that in case the resolution plan is not approved because of various reasons, then what happens? The company goes into liquidation. Yes, the company goes into liquidation. See, whenever the company goes into liquidation, what happens? Any buyer will come, and the buyer will purchase the land, and whatever the construction is there, he will purchase, and the money which is available with the liquidator can be distributed amongst all the creditors, including the home buyers. But then there are like riders on this. First rider is that the NCLT would normally say that you will keep this company as a going concern, and the RP will try to handle it. RP would try to complete the project, or RP would try to sell the company as a going concern even during liquidation process. That is the first normal condition which would come even in the liquidation order, and still at that time also the kind of liquidation as a going concern can be done. However, the resolution plan like solution would not be available. Somebody might say that yes, we would settle with all the creditors, but that's a very complicated thing. The only thing that is practically possible that somebody buys the entire land and the under construction property, and that amount is distributed to the creditors. But then make sure that till the time an order comes from any adjudicating authority regarding the home buyers being secured financial creditors, till that time it is very risky for the home buyers to let the company go to liquidation, because in those cases the banks would be secured financial creditors and the home buyers would be unsecured financial creditors, the position which stands today. It is only we are trying to make home buyers as secured financial creditors based on our own study, but then no court has given an order so far. While we are submitting our resolution plans, considering the home buyers as the secured financial creditors, and we are creating a complete discussions in the resolution plans, why we are in the information memorandum, that why we are considering the home buyers as secured financial creditors. So yes, the liquidation is scary till the time the home buyers are considered as secured financial creditors. They would get after the secured creditors get.
I saw a couple of questions being asked about, in case I've already filed a case in NCDRC, can I go to RERA? Or I have already case in RERA going, can we look at IBC?
Yes, There has been many cases where the home buyers have taken multiple options, and then finally when they realize that the RERA would only give them decree and the consumer court also would give them a decree. However, the decree is not sufficient because there is a difficulty, there is a practical difficulty. In case any builder accepts the decree and makes payment to that person, then everyone will make a beeline outside the office of RERA or the consumer court. Getting a decree is only a time consuming thing, but then nothing else. The decree can be taken and the money would be available from the home buyer along with the interest. There's nothing better than this in this scenario. But that's not happening because the builders are not giving that kind of money, because they will say that we don't have the money. So it is very difficult to get that decree implemented. So yes, anyone who actually has an order or a consumer court order or even have filed a case, they can go to the IBC. There are two cases which has recently been given by the appellate authority, and they are saying that the corporate debtor was prevented from some kind of force majeure circumstances. It was not the default by the corporate debtor per se. There were some other circumstances because of which the possession got delayed, and also they added that the home buyer have also gone to RERA and home buyer have also gone to consumer court. So he's not. So those kind of CIRPs were quashed. Only couple of orders. Of course, those are not going to survive longer, and we are sure that uh, as far as the law is concerned, yes, in case there is a default, and even if you have approached RERA, you can still go to IBC. So any other questions?
One question from Mr. Vishwanathan. He says that what happens if the company's properties and documents are in the custody of CID, and I think he meant CBI or something, and the assets are about to be auctioned?
No, I think once the I see insolvency and bankruptcy proceedings starts, the CIRP starts, all the documents will have to be released in favor of the RP. Section 32A was inserted in the law in the month of January 2020, and that actually protects all the companies against any kind of criminal offenses. All the assets would be detached, and the CID of the state government, state police. CID is a state police department. In some of these states, it is called Economic Offense Wing. In some of these states, it is called the CID, which is the Criminal Investigation Department. So these departments would not have any power after the insolvency starts. So they will have to release everything in favor of the RP, and the RP will start the process without having any adverse from the CID investigation or CBI investigation or the economic offense wing of the state police. So the resolution process would continue, and they would have to give the attachment. They will have to detach the asset.
Then there's a question from Mr. Vaibhav Tayal, and he is asking that how does so if there is a settlement happening between a financial creditor and a CD, how can a third party approach for an intervention application? I think this is something which is not concerning home buyers per se. But yes, it might be a possibility that if one creditor is trying to settle his loan or his outstanding with the CD, home buyers can approach the NCLT and maybe intervene in that application. Maybe you can...
I think there has been cases like in the case of Supreme Infra. We also faced all these cases because there are 26 applications, and the first application where the CIRP started, and there was a settlement between these two parties, and by that time all these 26 or even 40 maybe all those parties they were also given the order by the adjudicating authority. Since the CIRP has been started, now you go and file your claim before IRP, and later on when the settlement was done, and then they again had to come back to the adjudicating authority, But in that case, I think there was an ANCLAT order that all those people, I think it was a Supreme Court order, all those people who actually have been told, all those people who have been told to file your claim before the IRP, they can revive those applications in case the CIRP is quashed. So they can go to the adjudicating authority, make an application so that their earlier application can be revived, and that application will start from that point where it was left. So that can be done, and I think the intervention is genuine, because see, if you're settling with one person and you can make the court fully aware, like this company is actually insolvent, settling with one party doesn't mean that it actually gets completely resolved. However, if the section 12A application has been properly filed, there was an order from ANCLAT in the case of Supreme Infra that yes, it has to be withdrawn. However, the uh, people who have been told to go and file their claim to IRP, they can go and approach adjudicating authority for revival of their old applications. So I think we can complete how the resolutions can be found under IBC. What kind of resolution plans are made. As I said, that the home buyer and the builders can actually understand the total economics of a project, and then they can submit a resolution plan. They can understand how much money is due from home buyers. They can understand what is the present value of unsold inventory. They can also calculate what is the cost to complete, and then they can prepare a resolution plan. So in case the money is lesser, then the home buyers can also propose that yes, we will contribute additional amount because to bridge the gap. So then the construction can be restarted after recovering from the home buyers, and then the balance terms of the payments can be changed according to the as compared to the BBA, because depending upon the circumstances of each case. Like see, as I said, that the possibilities are that in case there is a shortage of fund, then the cost of construction can be reduced, and the flats can be or units can be offered to home buyers without interiors. In case further it is short and the home buyers are not agreeing for the uh, taking possession without interiors, then they can be told to submit or pay additional amount, because the earlier amount was lost by the builder, so they would pay additional amount, and then the resolution plan can be approved. Unsold inventory can be sold, like that's of course like depending upon the value in the market, and the market dynamics would work. As I said, the operational committee, architects, all this I've already said how the resolution plan can be made. Then there is as I already said, that the project-wise construction, the understanding, project-wise contribution, the project-wise balance sheet. See, the project-wise assets and liabilities would have to be calculated. Then only a resolution plan can be achieved. Otherwise, the home buyers of one project would be satisfied, home buyers of the other project would not be satisfied. So the resolution plan will never actually get approved. So if we want to get a resolution plan approved, then we actually have to work on each segment of the home buyers for each project. Then only a project can be approved. Then only a resolution plan can be approved. If you don't look at all the projects and separately, because no association would agree that the surplus money from my project, as the surplus money from my project is used for the other projects. Yes, as far the company is concerned, we have to do that. But whenever we talk about the additional contribution, it will be calculated based on the project. If one project needs additional contribution from the home buyers, that doesn't mean that every home buyer will give on the other projects also. However, any additional money, any surplus money from one project can be used for the other projects. So these kind of settlements have to be done between the home buyers associations, and they will fight for their own project. But the one person has to be very strong to understand their need and to explain them logically. Then only they come to a final solution. And the only risk with them is that in case we would not agree, the company will go to liquidation, and the banks will take bigger slice from the assets of the company, and we will be second in that case. So that one risk motivates them to settle. and they normally settle amongst the associations, and that works well. As I said, that the committees can be made for implementation of the each project separately. All the associations should come together. The land development agency can be offered an amount based on the liquidation value. The lease cancellation and the lease development agencies cannot survive, as it would boomerang, because see, the lease cancellation, although the Noida Authority and the Greater Noida Authority has cancelled some of the lease, but this is not going to survive. It is only a time it will take, because the adjudicating authority or the Supreme Court will give that kind of order, that if the lease is cancelled by the Noida Authority, was it informed to the home buyers, to the allottees? The allottees were giving the money even after the lease was cancelled by the home buyers for multiple years, and this is considered a connivance, because as per the Amarpali case, in the case of Vikram Chatterjee, in first couple of orders, it was written by the Supreme Court that in case the lease is cancelled, then why the home buyers were not informed? How the home buyers continuously paid money, and was it not known to the Noida Authority that the builder have already booked the flats, and builder is taking money from the home buyers, but he is not making payment to the Noida Authority? That's something which is everyone knows. But then the cancellation of lease by the land development authority is not going to survive. Nobody would say that the Noida Authority would cancel the lease where there are 2,000 home buyers sitting on that land and the project is already 50% constructed. However, the NCLT says in one of our project, NCLT say that I do not have power to direct the Noida Authority to cancel the to remove the cancellation, or to quash the cancellation order. So that power they said we don't have. You will have to go to the Supreme Court. So we have filed an appeal to NCLAT against that order of the NCLT, where it is said that I do not have any power to direct the Noida Authority to renew the lease deed. So then we have gone to the NCLT, and let's see what happens. We are very, very confident that this particular order that we will win. In case not at appellate authority, then to Supreme Court. No court can afford to say that the lease is cancelled and the home buyers are stranded with half constructed buildings. So that's something which is not going to happen. However, NCLT just said that we don't have that kind of power. We also have a scenario where the mostly home buyer says that what about the fraudulent transactions? What about the money which has been diverted by the promoters? How are you taking care of that part? And you are asking money from us. See, what home buyer thinks that as if the RP is asking money from them. Whenever there is a resolution plan comes, the home buyer thinks that the RP is asking additional money from them, and they actually they can come on you very heavily, that you are not taking care of the fraudulent transactions. You are not even taking care of the cash which has been siphoned out. You see, that's something RP has to do. It is the duty of the RP to do that. Practically, it will be based on your own determination. It will be based on the forensic auditor's report, and it will be based on the adjudicating authority's time. All these things may take time, but the resolution plan would not wait for all this. See, in the court, in case you file an application under section 43, 45, 50, 49, 66, all this will take time in adjudication. And the stakes are very heavy. It is not possible that on adjudication somebody is going to contribute money, whatever fraudulently has been taken away by them. Then he will go in appeal to appellate authority and also to Supreme Court. However, it is the duty of the RP to find a resolution for the project, and that the project resolution is time bound. So we normally tell home buyer that that process will be taken care of. However, they actually get a lot of satisfaction when we write in the resolution plan that whatever money will be recovered under all these avoidable or fraudulent transactions, that will be distributed to the home buyers, and it will not go to the corporate debtor. It will be distributed to the home buyers against their, or it, in case they have taken over the company, then it will go to the same association. So this is the some clauses, because in case we read carefully section 43, 45, 50, the any amount recovered under these sections normally would go to the exchequer, would go to the corporate debtor. And if the corporate debtor has been taken away by some other builder, then why should that builder become undue enrichment? That money should come to the creditors against the suffering that they have done. So this is regarding the forensic audit part of it. So one question which was very, very important, it was coming again and again to us, it was the reverse CIRP. So it was held in the case of Flat Bars Association of Winter Hills versus Umang Realtek Private Limited, and this is an NCL 80 case. And in this case, one concept was given that the CIRP of the real estate company is limited to the particular project in which the default is there, and the CIRP is not applicable to all the projects of the company. Secondly, uh, the real estate company, the CIRP against the real estate company is limited to the project one. And the other part is, which is important in this case, is there was a intended promoter. He was an intended lender also. The promoter said that my project is almost complete at about 80%, 90%. If you give me the opportunity, I would complete the project and I would hand over the possession. So this changed the case, and this changed the mind of the bench. The bench thought that it might not be possible to find a resolution plan if somebody is coming and trying to invest money and complete the project. But what was the condition of that lender, intended lender? His condition was that whatever I invest for the project, that should be considered as an interim finance having priority over all the other creditors. So the court actually agreed for this. It was a promoter. The promoter company, which was the promoter company, said that in case the amount is invested by me and complete the project and hand over to the to all the home buyers, then the IRP would function along with the promoter. RP would monitor the entire process of construction and handover. There would be a certificate taken from the IRP for the complete implementation of the project, and then it will come to the NCLT, and the NCLT will quash the CIRP. So, quashing the CIRP by way of a resolution. This is why it is called a reverse insolvency. So when we see this reverse CIRP, the reason why it is called reverse CIRP is that the resolution is being done and then the CIRP is being quashed. So this is the in this case, the Uppal Housing Private Limited was the intended lender, and there was a tripartite agreement for all the sales done, and the tripartite agreement was between the RP, IRP, and the so all this is a very clearly settled. And a second case was Rajesh Goel versus Babita Gupta, and this was also a kind of replica of this case. So the again in the case of Pradeep Kumar Chaudhary, which is Dagcon India Private Limited, the brief reverse CIRP apply even if the corporate debtor is in the business of selling the flats, apartment shops to allottees. So this is the possibility of reverse CIRP. All this is the judgment showing the So Ankit, if there is a question, already we have crossed our time limit. 8:07 is the time, so we have handled this part also.
We have handled a lot many questions through the webinar only. So I don't think we need to mention each and every question. I can simply request our participants that in case any question is still unanswered, maybe they can repeat it. I can then take it up. Most questions have been taken up already. So
I would say that this judgment of Pioneer Urban Land and Infrastructure Limited is a landmark judgment on home buyers case, where their position, their status is completely defined, and that must be seen by all the insolvency professionals and everyone whosoever is working for the real estate companies. So the resolution plan can be implemented through a monitoring agency. Monitoring agency would, in case of anybody who is not complying with the provisions of the resolution plan, can again go to NCLT. So we still find and we conclude that insolvency is the best way to resolve the stress of a real estate company. It is the best way to find a resolution. It is the best way to break the trust deficit between all the stakeholders, and there is no other better solution available under any law, including RERA, because see, the RERA is good in case the builder, in case the company is solvent, and that too, even if the company is solvent, I haven't seen companies making payment if everyone goes to RERA. So with this, we can conclude. In case there are questions, I think still we can spend 10 minutes. Anandji can take up some questions, or Ankit can see what questions are there.
One question is with respect to, there were a few questions which talk about what can be asked for in the resolution plan. And so one question is a resolution applicant allowed to submit an open-ended resolution plan? In one of the resolution applicant have taken number of caveats to honor the resolution plan. Is it allowed as per CIRP process? So the questions, I think, is centered around the fact that what if the resolution plan is not honored by the resolution applicant? What happens to the resolution applicant in that case? Number one. Number two, perhaps the question is that what all can be asked for in the resolution plan? These are, I think, two questions that are still there.
So I think the various resolution plans that we have seen so far, I think maybe 17, 18, and we have seen this kind of a scenario that the first and foremost priority is we actually will have to see who is the voter. And the resolution plan of a real estate company revolves upon the fact that who is the voter. If a voter is only the home buyer and they have more than 66% power, the entire focus of giving away comes on to home buyers. And if the creditors are there, then the creditors also and the home buyers also have to be handled in a balanced manner. What can be asked with the resolution, see, like it is a very, very simple calculation. The unsold inventory is got a valuation. The amount which is recoverable from the home buyer is a kind of amount which is available. To my understanding, this is much better than any other company where the future we don't know what is the future, how much it will be producing, how much it would be selling. Whereas in the real estate, the figures, the financials are very clear. It is in front of you. The only difference would be whether the unsold inventory would be sold at this price or some different price, and that provision can be taken. However, I always see that in case a builder comes from outside and the builder takes over the company, and the builder will implement the project in case he is able to find some profit. So in case the builder will not be able to find some profit, he would not be able to sell the inventory, then he probably will leave everyone in between. So the best resolution is to just complete the project as a cooperative society by the resident welfare associations. That is the best resolution. And in this resolution, the only difficulty so far that we are facing is initially since the bid evaluation matrix, eligibility criteria. So that was in the first case we got an experience. So for all other cases, we are now prepared right from the beginning that the home buyers would be the best bet. So we are preparing our eligibility criteria, bid evaluation matrix, earnest money deposits accordingly. And we are also trying to say that there should not be any dispute between the various home buyers associations. So we try to combine them, and we try to resolve their disputes, and they come to us with a common platform, with a common objective of getting the flats handed over to them. So this way we can conclude our webinar today. And if there is still a question, I think you can always reach out to us. As I always say, that any question that you ask me, that adds to my knowledge, and this is the way of our learning. Thank you very much, participants, and it was a huge response. We are very happy to see all those people who are connected with us for the last more than 2 hours. So thank you. Anything, Anandji, anything that you would like to say? Ankit, anything that you say?
I would also like to thank the participants, obviously, for their patience, and they have been associated with us for 2 sessions of 2 hours and more.
Absolutely. Thank you very much. So we
in case any questions are not answered, we will, of course,